Hello everyone, thank you for watching my frequently asked question series. The next question that we have is, what if you pass without a will? What happens then? You know, a lot of people think, I don't have anything to really worry about. Let the state just handle it, and that's fine. For some people that may be an option that works best for them. It's not something I would recommend, but it is there because yes, the state does have a plan for you. If you don't have a will, state law will fill in the gaps. Basically what's going to happen is it's going to determine who your heirs and beneficiaries are. If you have a surviving spouse, that may be the person that is going to be the primary heir, then children after that. If there is no spouse or children living, it would go up to your parents to receive the estate, and then ultimately your siblings, nieces, nephews, cousins, and so forth. You know, it can get tricky if there's a blended family. If either you or your surviving spouse have children from a different relationship, it's not just going to be 100% then, so there's going to be some fluctuation there. If you have any kind of settlement after you die, you know, maybe you were in a car accident or a personal injury that caused your death, maybe it was a medical malpractice issue, something like that. Remember, your estate is going to be the one who is going to receive that money, and then that money is going to go, because you haven't named who it is, to what the state law dictates. Okay, it basically is just going to follow the family tree. It doesn't look at your relationship with those people. It doesn't look at the fact that maybe you have a long-term committed relationship with someone else, but you haven't married. So the person is not going to be entitled to any of your estate. So it's really important that if you have any concerns like that, that you want to make sure that your plan is laid out in writing, so you're not going to have to rely on the state law for you. The other issue is, when you do not have a will, whoever is going to be named as the administrator of your estate, the one who's going to have to take care of ensuring that all your debts are paid, that your final tax return is completed, and then in charge of distributing any income that is there, any assets of the estate, you have to remember that person's going to have to be bonded, and they may not be able to get bonded, which means someone may be in charge of doing all of that work that you would not have chosen to do so. And that's another reason why it's so important to have a will and have certain information like whether or not you want that person to be bonded in place. So keep that in mind. While there is a plan for you, even if you don't make a plan, it may not be the plan that you would choose. So thank you, and you can reach out to me with any questions at ralstonlawestateplanning.com. Otherwise, I hope you continue to listen to some of our other videos, and if I can be of any help, just let me know. Thank you.